Welcome to our second in a series of financial webinars designed to assist you and address various financial topics. Thank you for joining us this morning. Today we bring you Randy Johnson, a Chartered Special Needs Consultant with Infinitas Coordinated Wealth Counsel. Today he will be speaking about financial planning for children with special needs. Thank you for joining us today. Randy?
Yep, thanks for having me, guys. We'll get into planning for families with children with special needs. And first, let me explain, before we begin, let me take a moment to share with you some information about who I am and who we are. I'm what's called a Chartered Special Needs Consultant. A Chartered Special Needs Consultant is a financial advisor who's completed 120 hours of academic classes, in addition to holding various other designations like Chartered Financial Consultant or CFP designation. With the classes that I've taken help me help clients prepare letters of intent, which we'll talk about here in a second, and do financial planning for families with children with disabilities. So that's a little bit of background about my training and where I come from. So a life care plan is something that we're going to talk about today. What is a life care plan? Generally, it's recommended that parents of kids with special needs develop the life care plan. It's a coordinated program of future care planning, financial and legal strategies for people with disabilities and their families. A life care plan continually changes throughout the individual's lifetime and takes input from multiple specialties like financial advisors, attorneys, and accountants, along with a child's teacher and parents, most importantly. There are 10 steps in creating a life care plan. Step one is to address primary concerns or primary issues. In other words, we want to look at what's currently happening in your loved one's life. That's the first step. The second step looks into the future a little bit, and it's important to define what your dreams, goals, and wishes are for the care of your loved one. We want to ensure that the quality of life is retained for the child, regardless of whether or not the parents are around to provide that quality of life. And this is what a life care vision does. It describes what you as a parent envision for the future of your little one. Step three is to choose guardians and conservators. It's important to identify a guardian, someone who can step in and care for the person with a disability in the event that you're no longer around. A term also used is trustee. A trustee can be a different person or should be a different person in a lot of cases, or can even be a corporate entity who can manage the trust and prepare tax reports and perform other duties. We'll get more into trustees and what they provide here in a bit. Step four is to identify the financial resources. You know, what assets are available today, and where will the money come from to care for the child when he or she receives or enters into adulthood. So that's something that we want to identify, what resources are available. We also want to talk about what the current and future costs for the life care plan are. So how much will it cost to address your primary issues listed up here? And we want to determine what future costs could be of those services that are required to continue the care through adulthood of an individual with a disability. Step six is preparing a letter of intent. That's something we'll get into in more detail here in a minute. But essentially it documents the current situation of your loved one, and it's updated periodically, usually once a year. But we'll get into more of this here in a second. Preparing legal documents, wills, trusts, powers of attorney, healthcare proxies. You want to work with an attorney to ensure that the desires are carried out, whether you're here or not, and to be sure that all appropriate legal documents are in place in case of an emergency. This is something that, again, we will discuss primarily these two items, 6 and 7, here in a few minutes, and what trust, for example, can do for your loved one. Step 8 is to hold a family meeting to make sure everybody in the family is informed and involved. This may not be applicable to all situations, but it is important to communicate your desires to everybody who's interested within the family and helping with those desires. And then number 9 is the one that's most often overlooked, is to review the life care plan annually. That's important. You've got to make sure that you keep things up to date, and you'll see why here in a second, because it contains information about today, and that information does change from time to time. So in general, here are the components of a life care plan. We've got the vision, the life care vision. We've got the letter of intent. We've got information about guardianship, caregiver succession involved in the life care plan, financial resources that are available, and then the special needs trust. We're going to talk about the letter of intent next. I want to go further into that and show you an example to give you a better idea of what this looks like. For templates, you can find templates out there by just doing a simple Google search of a letter of intent, or you can just reach out to me and I'll be glad to provide you with a couple different templates to use. First, before we get into kind of what the template looks like, let's talk about what a letter of intent is and is not. It's not a legal document, but it is important, and a court could potentially consider your wishes in a legal proceeding. If there's a legal proceeding in your situation, a court may use this document to determine what your wishes are. Many families use a letter of intent as a scrapbook or a history of their child's life. While it's important to document the child's medical condition and medications, it's got other information in there about future wishes of the parents. Also, it's important to consider information from your child's special needs teacher. Teachers keep a detailed report, as you know, on each child that they work with, and should have access to information, and you should have access to this information for your own records. It'll also help you plan for the future more easily. Let me give you an example of why a letter of intent was important. I have a client who's got a 16-year-old boy with autism, and he's got communication difficulties and becomes quite agitated if he's not understood. His mom has learned over the years that the only way to calm him down when he does become agitated is to put him in the shower. If this is something that only mom and dad knew, and something happened to mom and dad, any future caregivers it would take them time to figure this out, and could be very stressful for this individual. So a letter of intent documents this so that any future caregivers would know what helps the young man calm down, and that's why it's important to have this kind of information available. So let's look at what a letter of intent document entails, what information it has. Again, this is just a generic template. Not all this information is going to be necessary for every situation, but it's pretty detailed in what it has. First, you've got general information about mom, dad, the child, and other guardians, advocates, trustees, and power of attorneys. So you want to make sure you document who's involved in the care of this of your child's life, from not just you, but all siblings and other interested parties. You also want to provide as much detail in layman's terms, which is important, when describing complicated, medical conditions and treatments. And so you want to have a detailed list of, from a medical standpoint, what is important and what's needed to care for your kiddo. You want to talk about day-to-day routines, activities, and skills of your child, and that's important too. So what does an average day look like? What kind of routines does your child like, dislike? What activities do they like, dislike? What potential skills do they have for the future and for today that can be utilized? And then when they're describing an average day, is important. What time does your little one get up? What time do they go to bed? What time do they like to eat? It's basically an autobiography about your little one. So we want to make sure that we get as specific as possible. Again, just a reminder, this document should be used, it should be written in a format that somebody can pick it up and know as much as possible about your little one without knowing your family at all. So that's what the document is intended for, and that's why you want to be pretty detailed in it. We're going to talk about education in the letter of intent. What kind of activities you participate in, both structured and unstructured activities. Provide additional details, and that's what this section's for, provide additional details, maybe not captured somewhere else that only those are important as well. Next is you're going to talk about the services and benefits your child receive. If you're at that point, you may not be at that point yet, but if you are there, and that's why this needs to be done annually, because those benefits and services are ever evolving. And the template we have talks about what services and benefits means, and that includes, and that's kind of listed right here. You want to talk about or indicate any service gaps or benefits that are needed but not being received, and then any plans that exist to obtain those benefits. You want to list all expenses and who's currently paying for them, whether it's parents, grandparents, guardians, third parties. Not every expense is paid for by mom and dad, although it may seem like that, but going forward, as your child ages, those expenses will be taken over by government benefits, which we'll get in here in a second. And then this is extremely important, listing how the financial picture would change if one or both of the parents passed away. Again, we want to ensure that that your child is able to live a life that you want them to live, that you envision for them, whether you're here or not to care for them or ensure that lifestyle is created. So we want to know what would change in the event that you're no longer here. So that talks about what a letter of intent is. And again, there's many templates out there. Just let me know if you need a template. You can shoot me an email, which my contact information will be here at the end, and I can provide that to you without any problem. So, going back to the components of a life care plan, that we talked about these earlier. The next item that we'll talk about are special needs trusts. Most families, most parents with a child with special needs has heard the term special needs trust. So we're going to talk about what those are, the different types, and quite honestly, why you would need one. And here are the reasons to create a special needs trust. Any kind of developmental disability, traumatic brain trauma, or spinal cord injury, medical malpractice. If you're have suffered from a personal injury serious enough to impact your future life or their future life, and then anyone receiving or soon to receive a structured settlement, which could impact their eligibility for government benefits. So it's not just for kiddos. It's for really anybody who's got whose life's been impacted by a disability. And there's two main types of trusts, which we'll get to. Let's also talk about the two types of government benefits that are available, because that's what a special needs trust is intended to protect, is these government benefits. So the first type is pension or insurance type of benefits. Here the benefits are based on your contribution or an individual's contribution to the program, and not necessarily based on an individual's financial need. An example would be Social Security Disability Insurance, or SSDI, and Medicare. An example of somebody who'd qualify for this type of benefit would be an adult who's been in the workforce for many years, who's maybe in a car accident that requires ongoing care the rest of their life. They would receive benefits based on their contribution into the system. Everybody pays taxes for these two items here, and your contribution into that system would determine your eligibility for this. Now, a lot of, or most children that turn into adulthood don't have work history and have not contributed into a system, so they would fall under the needs-based type. Here the government benefits are based on an individual's monthly countable income and resources. Income in excess of what's legally allowed could disqualify an individual from receiving those benefits, and that's something important. That's what the Special Needs Trust helps with. Examples of this would be SSI and Medicaid. You know, this type of benefit, this type of government benefit that most children with special needs who turn 18 would receive, since again they don't have any contribution into the pension or insurance type. So those are the two types of benefits. Again, we want to protect any kind of benefits, Medicaid or SSI, from getting taken away, and those benefits are only eligible if you have assets under $2,000. Okay, so you know, the good news is we can shelter some assets in a special needs trust, so they're not considered quote unquote available to the individual with a disability. And these assets can still be used by the individual, but only for specific expenses, which we'll talk about those expenses here in a second. So first, you know, a special needs trust is a legal document and needs to be drawn up by a qualified attorney. Now, there's a lot of estate planning attorneys out there, but you want to make sure if you do speak to an attorney that to write a special needs trust that they've got very specific experience writing special needs trusts. Most elder law attorneys are experienced with this kind of trust. So if you're looking for an attorney to write this kind of trust, you should look for an elder law attorney. They have more experience than just a general estate planning attorney, who they do great work, but special needs trust is very specific on how it's supposed to be written. And if it's not written in the way it's supposed to be written, it can jeopardize benefits that the trust was written to protect to begin with. A special needs trust is a means of providing supplemental benefits to an individual for specific purposes to enhance their quality of life. It can be used to, again, used to enhance the quality of life beyond the basic care provided by the government benefits that are received. Example of this would be to send a child to camp, take vacations, maybe travel to see other family members, purchase sporting equipment, and even to pay for therapeutic needs that don't fall under day living or maintenance expenses. So any benefits not provided by government benefits would also be allowed to be paid for through a special needs trust. Again, these proceeds, if done in a proper special needs trust, will not affect government benefits because the assets technically are considered unavailable to the beneficiary of the trust itself. So who can establish a special needs trust? Basically anybody who asks these two questions here can establish a special needs trust. Who will take care of him or her, my child, when I'm not around, and then how can I pass part of my estate without affecting government assistance? So this can be really anybody that's an interested party and a child with a disability, grandparents, parents, aunts, uncles, neighbors, real good close personal friends. Any one of these folks can establish a special needs trust. Again, a special needs trust coordinates available resources. This conserves your financial resources and helps eliminate the duplication of efforts. It ensures a continuation of government benefits that we've talked about. The trust can provide for supplemental needs that we talked about, and I've got a chart here in a few minutes that kind of talks about what those needs are, how to determine the difference between supplemental needs and basic needs. Improve the quality of life by allowing for vacations, cultural experiences, and other activities that are otherwise not available. And then most importantly, not most importantly, but one of the important factors of a special needs trust is it can direct financial or final distributions, meaning once a child with a disability is turned into adulthood, and then once they pass away, assets within that trust, and there's two types of trust. One of the trusts, you're allowed to name a beneficiary beyond the life of the individual with a disability. So you could have that money be sent to the siblings of the child upon that child's death as an adult. So that's an important distinction. You know, the trust document stipulates how the money is contributed to the trust or distributed, which is why you want to hire a trustee to adhere to that, and we'll talk to that here in a second. There is state-specific language, which is really, that's why it's important to hire an attorney to write the trust that is, number one, licensed in your state, and number two, that's got experience writing these trusts, because each state has a little bit different language on how that's supposed to be included, and it's important to have an attorney that knows that. A special needs trust names a trustee who's responsible for carrying out the terms of the trust agreement. You know, a trustee is an individual or an entity like a bank who oversees the distribution of money from the trust that makes sure that the trust is using money in a way that does not jeopardize the government benefits. Because of this, it's important to select a trustee that is used to working with special needs trust. Generally, what we recommend is having, most families want to have another family member involved in the administration of the trust, because, you know, the family members know the individual with a disability better than a trust department. So what we generally recommend is hiring a trust department at a bank that is familiar with working with special needs trusts, and that trust department's job would be to making sure that money is used for the right purposes within, you know, contained in the language of the trust. Their job is also to prepare you know, tax documents for the trust and to administer the investments inside the trust. The family member can be named as a co-trustee, and their job would be to be an advocate for the child and say, here's what the child needs, or the adult child, the adult with a disability by this point in time. This is what this individual needs, and they can be an advocate for that individual so that both sides are taken care of. The legal side is taken care of, making sure the trust is doing what it's supposed to do, and then the individual with a disability is also being taken care of. Like I said before, there are two types of trusts. There's what's called a first-party Medicaid payback trust. You know, you'll hear it called a first-party trust, first-party special needs trust more often than a first-party Medicaid payback trust. This is a self-settled trust. It's only available in limited situations. It is set up by the court. Okay, the beneficiary must meet a very strict definition of disability. It's irrevocable, which means once it's established, it cannot be changed. You know, so once it's there, and once the assets are inside the trust, it can't be changed any. After the death of the beneficiary, the state is reimbursed for all Medicaid benefits paid to or for the beneficiary. Now, this is different than the second type of trust, which we'll talk about. And that the second type is way more common than this type of trust. More often than not, this type of trust is provided for an individual that's, you know, had a disability later on in life, and any benefits that are received from Medicaid are then paid back. Let's say the individual, you know, received $250,000 in Medicaid benefits over their life. Well, then out of that first-party special needs trust would come upon the death of the individual with a disability, $250,000 would go back to the state to reimburse them for those benefits. So, needless to say, this type of trust is very limited in its use, but it is a type of special needs trust. That's important to understand the differences between the two types. This trust does not provide for basic maintenance, support, or services like food, clothing, and shelter that are otherwise provided by government benefits. So the more common type, the type that most everybody who's listening to this is going to use or talk to their attorney about, is called a third-party special needs trust. A third-party special needs trust can be set up by anybody, and not just the parents. Like I said, anybody who is an interested party in this, in the individual with a disability. It can be set up by a donor. A donor is a person who's giving money to the individual. They would set the trust up by gifting money into the trust, or by naming the trust as a beneficiary on accounts that passed to the trust at their death. And that's something that's important. When a special needs trust is established, it's only as good as it's only valuable if you actually use it. So any IRAs that you have, any investment accounts that you want to pass on to your child with a disability, instead of passing on directly to that individual, you'll name the special needs trust as beneficiary on those accounts. And that goes for everything: life insurance, any type of financial asset. If grandma or grandpa doesn't know about the special needs trust and they leave some money, to your son or daughter, there's things that can be done to fix that, but it involves an attorney and can be rather expensive. So that's why having a family meeting and making sure everybody's on the same page is so vital, so that everybody knows the existence of the trust. On a third-party special needs trust, there is no need to pay back Medicaid, which is why this one's used more often. And then upon death of the individual with a disability, the amount that's left in the trust can be passed on to other beneficiaries that are chosen by whoever drafts the trust. It could be charity, it could be other siblings, it could be anybody, a neighbor, whoever you want. As I said before, assets from a special needs trust cannot provide for benefits that are provided by government, but government benefits like food, clothing, and shelter. And we'll talk about that here in a second. Actually, let's go ahead and talk about that now. So we all know government benefits, are being cut back pretty much for all 50 states. So if something's being provided by a state right now in the form of a benefit, and that benefit gets cut back, a special needs trust is allowed to pay for that benefit because the state government cut back the benefit. So if there's a service that's being provided that's vital, it can continue to be provided out of the special needs trust without jeopardizing benefits. Okay, so here's kind of a little chart that kind of shows you what each of the two financial instruments pay for. For example, so you got sources of money comes from Social Security, Medicaid, and Medicare. So that's this bucket of money. Those are government benefits. They pay for room and board and basic personal needs. They also pay for care and supervision, employment/activities, and then medical care. All right. So those are the items that government benefits pay for. Everything else can be paid for by the special needs trust. Okay. Medical, dental care that are excluded from government benefits or social benefits, another way to say government benefits, gifts on special occasions, professional fees, maybe an accountant to file a tax return, fees such as that, vacations and trips, again, basic care if social benefits are cut back. So if any one of these are cut back, basic care can be provided by a special needs trust, and then personal hygiene and grooming costs can be provided for by a special needs trust. So that talks about special needs trusts. The role of any kind of financial advisor, any kind of financial professional, whether it's a CPA or even a legal professional and an attorney, their role is to help you understand the financial needs of the individual and how, the social, medical, and legal needs impact their life care plan. Okay, so it is important to work with all three individuals: a financial advisor, a CPA, and then an attorney. And then they provide a financial needs analysis. So when you're, saving for your retirement, and then you retire, your need doesn't stop when you're caring for an individual with a disability. In fact, that need, financial need, often doesn't stop until the death of that individual with a disability. So that's how financial planning for an individual with a disability is different in that, a typical financial plan pretty much ends when mom and dad pass away, whereas a special needs financial plan does not. It continues. And, it also, working with professionals will help you ensure that benefits won't be unintentionally jeopardized. And that's something that happens all too often. And that's pretty much the conclusion of what I have to talk about today. Here's my contact information. If you guys have any questions whatsoever, don't hesitate to reach out to me via email or phone call. I'd be glad to answer any questions. And now I think we'll open it up to questions.